back to those. So, jump back. He's coming.
Did you let the jail know I've got the seven sinks? Oh, perfect. Thank you.
All right, council, is there any of you that are connected that are not here on the Antaya versus Schulich et al. Case? Okay. All right, great. So we'll go on the record in that file. That's file number 2213998. And if I could just have, looks like everybody is unmuted. Ms. Peacock, you're here on behalf of plaintiffs, correct?
That's correct, Your Honor.
That's correct, John.
Okay, and maybe I can just have defendants kind of go around the horn with names and clients, please.
Alan Sullivan, Your Honor, I'm here. Northwest Emergency Physicians, Dr. Gunther.
Good afternoon, Your Honor. Sandra Lake here on behalf of defendants Schulich, Craven, and Kalkaska Memorial.
Good afternoon, Your Honor. Nick Arteva on behalf of defendant Munson Healthcare.
Good afternoon, Your Honor. Connor Morgan on behalf of Danette Wells, Dr. Elizabeth Hunter, and Sound and Patient Physicians.
Okay, great, thank you. All right, we're on the record today for purposes of a status conference in this file. I know that last month the court signed an order adjourning mediation, and as part of that order, just indicated that for today's hearing we would discuss new dates for closing discovery and for mediation to occur. So I'll just start with plaintiff, Ms. Peacock. Do you have any suggestions for what you'd like to see in terms of going forward and dates to be set by the court?
Yes, Judge, thank you. We've completed quite a few depositions. Sorry. See if that helps. It doesn't. We've completed quite a few depositions. We're still working on defendant depositions. My major concern is that my clients are unable to travel from Florida. Well, one, the case wasn't ready for facilitation. We haven't done enough discovery. And number two, your original order asked that the parties appear in person for the facilitation, and due to my client's severe handicap, that is, they currently live in Florida, that would be unsafe for them to travel here.
Okay, so what would you like to suggest going forward then?
You know, if they could the facilitation by Zoom, if the court, I mean, that's a burden on all the defendants to make them go to Florida. If the court wants to do it in person, I really think that's the only feasible way to do it. You know, my client, they don't have transportation. She's a quadriplegic. When her husband had to go into the hospital, she had to go into the nursing home because she didn't have anyone to care for her.
Okay. All right. I'll open this up to defendants. Does anybody have an objection to having facilitation with Ms. Peacock's clients appearing by Zoom for that?
I don't think that's an issue for our clients, Your Honor. If they want to appear by Zoom, that's fine.
Okay. All right. So Ms. Peacock, I'm not seeing any objections on that. So what kind of time frame should we be looking at in terms of when we can complete that mediation?
I think we need it. Oh, sorry, Alan.
Oh, sorry, then go ahead. Sorry.
Sorry, I was just thinking of something. I mean, if we're going to allow the plaintiffs to attend from Florida, you know, I'm not sure where our insurance people are exactly, but you know, having them come in, if we're going to do it by Zoom, should we have the defense have the same opportunity. If they need somebody to appear by Zoom, that would be okay as well.
Ms. Peacock, any objection to that?
I mean, how could I?
You'd be surprised. You never know. I'm just going to make sure. Okay, so what we'll say then, in terms of mediation for procedure, the court's going to allow any party to appear by Zoom if they prefer to do that. And I mean, I think some of the facilitators are even doing them by Zoom in general now. So I'm not sure even how much of an issue that would be. So the court is just simply gonna, I guess I'm gonna leave it up to counsel in terms of whether you want to do any part of that live or whether, you know, you want to have it just be a Zoom proceeding with the facilitator in general. But I think it's reasonable, especially nowadays, to have parties attend. You know, I mean, you all know the reason for in-person in the past was theoretically that put some pressure on people to want to settle if they're there in person. I don't even know how true that is based on what I've heard about facilitations post-COVID. So from the court standpoint, I don't have any objection to the extent that the parties want to do it by Zoom, doing it by Zoom.
And then, sorry, go ahead.
No, I was just going to say, what kind of time frame then?
I mean, I think we need at least another 6 months of discovery, given the number of parties and experts in the case.
All right, defense counsel, does anybody want a time frame different than that?
No, Your Honor, I
Okay.
think 6 months is good.
All right, so for purposes of today then, I'll prepare a status conference order that reflects that discovery will remain open for another 180 days, mediation to occur within that time, with the mode of mediation being any party that wants to appear by Zoom may do that. On behalf of plaintiff, and then I'll set it for another status conference at the close of that 180-day period. And then we'll see where we're at that point. Ms. Peacock, any other dates that I can address for your side today?
Not that I can think of, Judge. Thanks.
Okay, defense counsel, does anybody have any other dates that you'd like me to put into this order?
I don't think so, Judge.
Okay. All right, very good. Then I will send out this order with what we've discussed today. I will also send out notice of the date and time for that status conference about 180 days out, which will be by Zoom as we're doing today. Thank you all, counsel, for being present for this status conference, and everybody's free to disconnect at this time.
Thank you.
Thank you, Your Honor.
Honor.
Did you talk to Mr. Ziegler?
I was told by Janet that he was on his way over here, so
Oh, okay.
couldn't find him, but
Okay. All right. Oh, no, you just popped in here.
all right, well then I guess I'm sorry, just give me 2 minutes just to take this over to him.
Yes, we can do that. And then I'm going to bring your client in because he's in the waiting room right now as well.
Thank you.
Mr. Ziegler, Mr. Stig Nelson's just headed over just to drop off some documents for you, and then he appeared in person today. I think there was a mix up on that, so he's gonna be here in the courtroom, but he's popping into your office right now.
Okay.
To drop off those documents. Okay, looks like we've got everybody present, so we'll go on the record. This is People versus John Skubish, case number 153787. Excuse me, if I could have counsel put your appearances on the record, please.
Ryan Ziegler on behalf of the people, Your Honor.
Good afternoon, Your Honor. Frederick Stig Nelson on behalf of Mr. Skubitz, Your Honor.
Okay, and the record should reflect Mr. Skubish is present by Zoom video for this hearing today. This is an application to set aside some convictions. I did have a chance to review the file, the application, the criminal history that was submitted, and we did receive a response from the AG's office. So Mr. Stig Nelson, did you want to take some, well, first of all, let me address just the technical requirements. Mr. Ziegler, on behalf of the people, would you agree that Mr. Skubish meets the technical requirements to have these set aside?
I do, Your Honor.
Okay. And I would agree with that as well. And I think the AG's office, that was their opinion. So that leaves a couple factors to be addressed. Obviously, Mr. Skubish's behavior and circumstances since the convictions, as well as whether or not it would be in the public interest to have it set aside. And then, of course, with regard to the OWI offense, there's a couple extra findings. And that's whether or not Mr. Skubish has benefited from rehabilitative or other educational programs, and what he's done in terms of that issue, alcohol use, since the conviction. So, Mr. Stig Nelson, did you want to take some testimony from your client?
I do, Your Honor. I also have 2 letters that are written on Mr. Skubitz's behalf. I'm sorry that they're getting to the court so late, but one of them we didn't get from Mr. Skubitz's friend, Mr. Galicio, until today. So that's the main reason I'm here in person, to deliver these to you.
Okay.
I have shared them with the prosecution. They do have copies.
Okay.
The other letter is from Mr. Skubitz's wife.
All right. And I normally don't take sworn testimony, but if you'd like to have a colloquy with Mr. Skubish to kind of establish those remaining elements.
Absolutely. And just to understand the court, do you need me to have him testify to the other findings with regard to the felonies and assault of crimes, or we're stipulating that those are met as of Mr. Ziegler's?
Yeah, I think we're good in terms of all the technical requirements. It's just those kind of public interests and his behavior since that I would need to make findings on.
May I proceed from sitting down?
Yes.
Okay, thank you, Your Honor. Mr. Skubitz, could you state your name for the record? I think you're muted.
Yeah, you're, Mr. Skubish, you're not muted on my end, so I think there may be something that's not connected. You might have to plug in a microphone or something on your end, or enable it on your computer.
Try to log out, log back in.
I think it's a hardware issue because he's not muted. Usually that's when that happens, their microphone isn't plugged in, or he doesn't have a microphone connected to that computer somehow, or whatever device he's using. Mr. Skubish, did you connect? It looks like I'm letting you into the hearing on another device here, but that one is muted.
I think he's connecting to his phone.
Hello, can you hear me now?
Yes, we can hear you. Yep, thank you.
All right, Mr. Skubic, can you just state your full name for the record?
Joseph John Skubish.
And Mr. Skubic, you're here on your application to set aside 3 convictions that stem from the single incident back on July 10th of 2015, right?
Yes.
And let's start with addressing the sort of the obvious factor here, that just from looking at the nature of the convictions and the facts that alcohol was a big factor here in these convictions. Is that right?
Yes, that's correct.
Okay, so now we have a feedback issue because you're connected on 2 devices. So
Okay.
the second device, you don't have your camera on, so can you turn that camera on, and then we'll disconnect it from the other device? Or
Okay.
turn down the volume on one of them?
How's that?
I think that works. Okay, go ahead.
Thank you, Your Honor. I apologize. So obviously, let's talk about the alcohol. What steps did you take to address your consumption of alcohol and your use of alcohol subsequent to your September 9th, 2015 convictions?
Well, I was subject by the court to take urine tests, which I took those and submitted them. I also was a regular daily, sometimes twice a day at AA. I also sought psychological help, where I was in counseling for roughly 2 years. As of this point, I still attend AA meetings 2 to 3 times a week.
And are you sober?
Yes.
And tell the court, please, about how getting sober has affected your life.
Well, it's affected me greatly, especially my relationship with my wife and my kids. You know, they're no longer embarrassed to be around me for the most part. Health-wise, I've also lost somewhere pretty close to 60 pounds since I've stopped, and really put myself in much better physical shape as well as mental shape.
The letter from Mr. Galicio talks about your involvement with some of your kids' sporting programs. Was that something that you were involved with to a greater degree subsequent to getting sober?
Much more so, yes, Your Honor. It was football, basketball, soccer, softball, much more involved. I wasn't going out after work with friends. I was heading to parks to help coach.
And talk, you mentioned your health. What are some of the benefits that you've seen?
Well, I mean, I've lost close to 60 pounds. My blood pressure has come, I was on high blood pressure medicine. It's come down to almost normal. So pretty much I'm much better health-wise all around. I work out now 5 to 6 times a week just to maintain these levels too.
Have you been able to manage your work stress in a better way?
I have, yes. Well, I changed roles a little later on, and that somewhat relieved some of the pressure that was 24/7 that I felt that I was under.
And let's talk about your plans moving forward. What is your current business, or what are you currently doing for work, and what are your future plans for work?
Well, currently, that's one of the reasons I'm, aside from liking to get this off my record, I'm currently CEO of a power company called Allegis Power. We're in the development of renewable energies, and we're in the process of trying to raise money for this venture. And I'm worried that this may be a blemish for not just myself, but my partners moving forward.
Is the renewable energies, is that something that you have you been in the energy sector for a long time?
I've been in the energy sector my whole life. I was mostly on the oil and gas side, and just recently I've moved to the renewable space, basically the last about 4 years ago. I left a company that was in Fort Worth to start our own company here in Houston.
Just so we're clear, the convictions you're concerned is that when you're seeking to raise funds, if they see that a person who's an officer or manager of the company has these convictions, that would inhibit the company's ability to raise those funds?
I'm not sure. I've been open with my partners about this. I've also been open that I'm trying to get it expunged as well, so they're familiar with it. I'm not sure what the other potential investors might see.
I don't have any further questions, John.
Thank you. Mr. Ziegler, did you have any questions at all?
No, thank you, Your Honor.
After hearing from Mr. Skubish, Mr. Ziegler, did the people take any position on whether or not the court should grant the relief?
Your Honor, I believe he's technically eligible. I also don't see any reason why the court would not grant the relief. I think based on his testimony, he's been sober. He's seen an improvement in his life. There are also things that he wishes to do which would benefit not our community, but the community in Texas, for which the expungement would benefit. So for those reasons, I would support the expungement.
All right, thank you. Again, I did have a chance to review the file prior to today's hearing. It does appear that, I mean, these issues all arose from one incident, these convictions. So these aren't multiple convictions over a period of time. It's all based on essentially one bad circumstance that Mr. Skubish had back in 2015. Based on the letters that were submitted and his statements for the record here today, the court finds that he has benefited from the rehabilitation aspects of his sentence in this case, and that he is no longer using alcohol and is not a public safety concern. Based on his activities as well as what he is wanting to do in terms of his business, The court also finds that his behavior and circumstances since these convictions, as well as it would be in the public interest to expunge these so that these convictions don't in some way inhibit his future business dealings. I think it's in the public interest to ensure that that's not going to happen because of these things. So the court finds that all the statutory requirements have been met and the court will grant the relief. Mr. Stig-Nelson, do you have a proposed order?
I do, Your Honor, and I have shown it to Mr. Ziegler prior to the hearing.
Okay, Mr. Ziegler, do you have any objection to the form of the order?
No, Your Honor.
Okay. Okay, so I'm signing that order now. We'll hand that back to you, Mr. Stig-Nelson. Anything else you need to address for the record?
No, thank you, Your Honor.
Mr. Ziegler, anything else from your side?
No, Your Honor, thank you.
All right, Mr. Skubish, good luck to you in the future. That's all for today's hearing, and you're free to disconnect at this time.
Thank you, Your Honor.
I'm gonna have those letters be made part of the file.
Okay, thank you, Your Honor.
Thank you. Court's next hearing is set for 2:15. We'll be in recess until that time. All right, Mr. Leonardson, are you able to hear me okay?
Yes, I am, Your Honor.
Okay, and you're here on behalf of plaintiff Beth France?
No, I'm here on the defendant, Kelvin France.
Okay, gotcha. Okay, there's Mr. France. Okay, so we'll go on the record in France versus France. This is case number 2314248. Both parties are present by Zoom video. Mr. France is represented by Mr. Leonardson. This is set for a pretrial scheduling conference in this case today. Mr. Leonardson, from your standpoint and your client, can you tell me what the issues are and what we need to do for scheduling in order to get this case resolved?
Yes, thank you, Your Honor. There is some property, there are property issues, and also there's a request for spouse. Both parties are on limited income. My client is on a help and receives only partial payments towards that claim. I request two things. Ms. France isn't represented by an attorney. We have attempted to meet. We've offered a chance of meeting, which was turned down. We would like to attempt to mediate, if possible, to help Ms. France and to keep things rolling. So we're asking the court to consider ordering mediation at this time. And we also request that the friend of the court prepare a recommendation for spousal support. This is a long-term marriage, but the difficulty is this is certainly one case where two cannot live as cheaply as one. And they're both stating they have limited income. My client is willing to make some sacrifices, but the request by Ms. France is $600 a month for a period of 6 years, with his only income being a disability. That doesn't seem reasonable or possible. So we're asking for a recommendation as it relates to spousal support, and we're also asking for the possibility of court ordering mediation to attempt to resolve this before trial.
Okay. All right, thank you. Ms. France, can you unmute yourself, please? Thank you. So Ms. France, what Mr. Leonardson is suggesting is that you and Mr. France participate in mediation. That's where you sit down with a neutral third party and they try to see if they can help the two of you reach agreements as to things like dividing up assets or property, as well as spousal support. Do you have any objection to participating in that process?
No, Your Honor.
Okay. So I think what I'm going to do is I'll set this for about 90 days for discovery, the parties to participate in mediation during that time, and I'll refer that to this case to community mediation. So Ms. France, they will get in touch with you for a time that works with you and Mr. France and his lawyer to set up that mediation, okay?
Okay, thank you.
And then Mr. Leonardson, if you can prepare an order to the court referring this to the friend of the court for a recommendation on spousal support.
Yes,
And then I'll sign that and then we'll get that from friend of the court, okay?
Yes, thank you.
Okay, thank you. That's all I have for and then I'll set it for a status conference at that 90-day mark. And if the parties are able to reach agreement, then we can enter the judgment at that time. And if not, we can schedule further from there.
Thank you.
Okay, thank you, Your Honor.
Thank you. Ms. France, did you have any questions at all?
I just gonna one more last request. I agree if he can pay 600 a month for 6 years. If he able 300 a month, I agree. But
Okay,
I would like to ask the dependent if I can stay until next year in our house after winter.
okay, those are all things that Mr. Leonardson's been able to hear those statements by you, so he can take that back to his client. And then those are things that you would be able to discuss further in that mediation process, okay? Okay, all right, thank you, that's all for today. All parties
Okay.
are free to disconnect at this time.
Okay, thank you, Your Honor.
Thank you.
Hindi na.
All right, sir, is your name Seth Hart? You're muted. Could you unmute for me? There we go. Is your name Seth Hart?
Yes, it is.
Okay, great. Thank you. And ma'am, can you tell me your name, please?
Carrie Hart.
Carrie Hart. Okay, great. All right, we're on the record now in, excuse me, Hart versus Hart. This is case number 2314209. The record should reflect that both parties are present today by Zoom video. And I have this set for a final hearing to enter a judgment of divorce in this case. And Ms. Hart, is that how you wanted to proceed today?
Yes, sir.
And Mr. Hart, is that how you wanted to proceed as well?
Yes, sir.
Okay. So I'm going to place you both under oath. I've got some questions that I need to ask each of you. These are the questions that I'm required to ask to establish the grounds for divorce under Michigan law. Ms. Hart, because you're the filing party, most of the questions will be for you. But if you could both please raise your right hands. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you. You can lower your hands. Ms. Hart, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes, sir.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes, sir.
Had you been a resident of Kalkaska County for at least 10 days?
Yes, sir.
In the complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes, sir.
Does that remain true today?
Yes, sir.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No, sir.
Are you currently pregnant?
No.
Under the proposed judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes, sir. I understand.
All right, and you and Mr. Hart have already divided up all the property of the marriage, is that correct?
Correct, sir.
Do you own any real property together or real estate?
No, sir.
Okay. I'm going to correct in this proposed judgment that I have, it indicates that you do own real estate together, so I'm going to change that, okay?
Okay.
All right. Mr. Hart, have you heard all the questions that I've asked Ms. Hart?
Yes, sir.
Have you heard all of her answers?
Yes, sir.
Do you have any reason to believe that any of the answers she gave were not true?
No, sir.
And you also would not be receiving any alimony or spousal support as part of the divorce. You understand that you would also be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes, I do.
And do you agree that you and Ms. Hart have already divided up any assets or debts of the marriage?
Yes, sir.
All right, the court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce. Ms. Hart, are you asking to have your last name changed?
No, sir.
Okay. So if either of you would like to get a copy of the judgment for your records, you can contact the clerk's office here in Kalkaska to make arrangements to get a copy of that. But I've signed the judgment with today's date, so the divorce is final. Ms. Hart, do you have any questions at all?
No, I do not.
Mr. Hart, do you have any questions?
No, I don't.
Okay, thank you. That's all for this hearing today, and you're both free to disconnect at this time.
Thank you, sir.
wasn't so noisy.
What
Like
you
a
can do about it.
cellar trap door.
All right, Mr. Corcoran, are you appearing on the West versus Spink matter?
Yes, Your Honor, I am.
Okay, I'm gonna put you back in the waiting room for just a little bit here.
Okay,
And Mr. Bear, you're here on Munson versus Barrett, is that correct?
That is correct, Your Honor.
Okay. All right, we're on the record in Munson Medical Center versus Craig Barrett, case number 2214014. We have Mr. Bear here on behalf of defendant Barrett. This was set for hearing at 2:45. I don't see any other counsel appearing. It's now 2:47. Mr. Bear, this is your motion to allow some additional discovery. I will say that I didn't receive any kind of response to your motion, at least none that was given to me as a judge's copy.
Who's the other attorney on this? Is it
Scott
Leonard?
Brenner.
Oh, okay.
So, Mr. Bear, is there anything that you wanted to state in support of your motion today?
Yes, Your Honor, I just want surprised opposing counsel isn't present. He could work and have communicated said. The motion has to do with a very limited discovery. What I did is in July, as stated in my motion, I emailed opposing counsel saying I would like to know what the cost was of two items which of the bill in question. Didn't really see it as something requiring a lot of formal discovery. It's two numbers. I didn't receive a response. I then filed an interrogatory, and I received saying that, well, you're too late. It ran a week ago or something. And I said, well, gee, all I want is what your client paid for these two items. And so I filed this motion. And the reason, Your Honor, that I think the discovery is that I'm only looking at the cost of two items, which make up 66% of the bill. And I think it is relevant to the reason of their bill. And I don't see where I'm causing any by asking for it.
All right. I think based on the lack of any written response, in spite of, there may be some other communication mix up why counsel's not present here today, but they certainly didn't file anything in writing that I can see objecting to the motion. So I think based on that and the failure of anybody to contest it here today, that the court should grant the relief. So if you would prepare an order that reflects the ruling today and submit that under the 7-day rule, the court will sign that. Is there anything else I can address for your side while we're here on the record today?
No, Your Honor. You and good afternoon.
Okay, thank you. And you're free to disconnect at this time. Okay, Ms. Spink, can you unmute, please? Thank you. Are you able to hear me okay, Ms. Spink?
Yes.
Okay, and Mr. Corcoran, are you able to hear me?
Yes, Your Honor.
Okay, we're on the record and I guess now it's Beckwith versus Spink. This is case number 2314111. The remaining parties are present here or their counsel. This is set for a status conference today. Mr. Corcoran, I see, looks like the end of August, there was a dismissal with regard to Ms. Fink and Mr. West's claim, but Mr. Beckwith's claim remains. Can you tell me the status of where we're at and what you'd like to see happen today in terms of going forward?
Yes, Your Honor. We did dismiss the complaint filed by Mr. West in this case because there was some overlap with his pending appeal from a trial we had last year with Judge Powell. With regard to Mr. Beckwith, we have entered a default, Your Honor, but I have not proceeded for default judgment. That would be the next step. I have had a brief discussion with Spink's attorney in this case. So I guess I would suggest that I file that motion and schedule it. And if Mr. Gilbert wants to appear on behalf of Ms. Spink and defend that, then we can have that heard at a later time.
All right, thank you. Ms. Spink, is there anything that you would like to say regarding going forward in this case?
No, it was already handled through Judge Powers. The order was already given. As far as I'm concerned, it should have been over 2 years ago with his order.
Your Honor, Mr. Beckwith was not a party to the other trial that we conducted last year. So that will be an issue that her attorney can bring up in defense of a motion if we have one.
Right, okay. Mr. Corcoran, how much time do you need to get that motion filed?
If we could schedule it sometime in early November.
Okay. All right, so I'm gonna just put as part of the status conference order that that it needs to be filed and heard within the next 60 days. And then Mr. Corcoran, if you can contact my office and get a date and time in November to set that for a hearing and then get that noticed up.
We can do that.
And then, okay, and then we'll decide where to go from there. Ms. Spink, if you are going to have counsel appear, then your lawyer would need to put an appearance in prior to that hearing, okay?
All right, thank you.
Thank you, Your Honor.
Okay, thank you. All parties in this case are free to disconnect this time.
Thank you. Have a good day.
Okay, looks like we have all council connected. We'll go on the record in Nellis versus Munson Healthcare, case number 2113787. If I could just have council put your appearances on, starting with plaintiff, please.
Good afternoon, Your Honor. John Elliott.
Mr. Hen, you're muted.
My apologies, Your Honor. Bill Hen on behalf of Kalkaska County Hospital Authority, Eden Center, Kalkaska EMS, Michael Bryan, Yale Miller, and Kent Aylesworth.
Good afternoon, Your Honor. Gretchen Olson appearing on behalf of Munson.
All right, thank you. We're on the record today for entry of an order arising out of a hearing we had a couple weeks ago on some motions. I did have a chance to review the objections and the proposed orders. Mr. Hen, any oral argument that you wanted to present today?
Your Honor, I would just say that after reviewing the response that the plaintiffs filed to our objection, which included some quotations from the hearing itself, it is my understanding now that the court meant for count 2 to apply to the individually named defendants. So I don't have any objection to that anymore. I do object to the characterization in the plaintiff's 2 submitted orders of the vicarious and ostensible agency claims, because I believe that what the court said was that those are not independent causes of action, but that the plaintiff is free to develop them in connection with the cause of action that survives, which is count 2. And the way that those were worded in at least one of the orders submitted by the plaintiff was that this was an issue that would be decided by trial by the finder of fact. And I don't think the court quite went that far, so I didn't want it to extend out that far. The other real issue I have with the second order that was submitted by plaintiff's counsel is that it starts to use the term ordinary negligence, and it says plaintiff's claim is for ordinary negligence. I don't believe that that's true. I don't believe the court has decided whether the plaintiff's claims sound in ordinary negligence or medical malpractice. Those are the 2 terms that get juxtaposed. I think that all the court decided on our motion, which was for summary disposition based on governmental immunity, is that there was no gross negligence as to the individuals, but that the standard applicable to them under the public hospital exception is negligence, not gross negligence. And so I don't believe that the order should state anything about whether plaintiff's claim sounds in ordinary negligence, because I think that's used in opposite of medical malpractice, and I think that would confuse the court's ruling. And then the last thing, plaintiff's counsel and I disagreed on whether the court intended the dismissal to be with prejudice or without prejudice. I took the court's ruling to be with prejudice. Plaintiff's counsel disagreed, and I think that the court should clarify that.
All right, thank you. Ms. Olson, on behalf of Munson, I received your response essentially concurring with Mr. Hen's objection. Anything that you wanted to add to that today?
Well, I did want to indicate, thank you, Ronnie, first of all, I did want to indicate that I agree with Mr. Hen that there was, I didn't like the wording of plaintiff's order because it made it sound like we on behalf of Munson would not have another opportunity to bring a motion on ostensible agency or vicarious liability. And I did not want that to be memorialized in any way, shape, or fashion in an order. So I found that to be confusing. Mr. Hen has submitted an additional proposed order that this morning that I agreed with, which indicates the following. This order does not decide any issue of ostensible agency or vicarious liability as to any defendant. And I think that that's more accurate.
Okay, all right, thank you. Mr. Elliott?
Thank you, Your Honor. Your Honor, you know, I look at it a lot simpler. I look at what the court actually said, and that's what I usually assume the order to be. Your Honor, you said that claim 2 ordinary negligence will go forward as to all defendants. You said it multiple times, and I clarified it at the end. It now sounds like Mr. Henn is not objecting to that. What Your Honor actually said about the ostensible agency and vicarious liability is what we put in the order, that we are free to argue it. You said it's not going to be separate claims. You're dismissing them as separate claims, but we are free to argue it. You went on and we quoted everything as to exactly who it could be argued to, which is both entities as to their either agents or employees. I think it was very clear what the court said. I think our first order reflected that, and our second order in our response, we essentially just took the exact wording from the court to make it even clearer if it was not. But I don't think anything that we put forth was not clear. On top of that, I do find it disingenuous that we're here today in the first place arguing about whether the individual should be in, because we all were there at that hearing. It was clarified numerous times. And the day before our hearing, Mr. Henn's partner, Mr. Lusprance, received the Court of Appeals opinion, Schrimmer versus Williams, also finding negligence against individuals in an almost exact same situation, 2 EMS employees injuring a person. I don't think we should have had to been here today. We're not here to re-argue the issues. We're here to memorialize in an order what the court said. And Your Honor, what you said is, I believe, memorialized in both of our orders. The second one is pretty much word for word. And I'd ask you to enter either of the 2 orders that plaintiff has proposed.
Okay. All right. Again, I had a chance to review the filings of the parties. I did have a chance to review the court's ruling at the motion hearing, and taking into account all of that along with the arguments of counsel here on the record today. Number one, I think, you know, sometimes you can get overly technical with entry of these orders, particularly when there's so many different issues involved. So I kind of understand where everybody's coming from here in terms of trying to nail down all the specifics of the ruling. But I think when you look at this in the context of the issues that were actually up for hearing in that motion, and the context really was in the context of governmental immunity. And at the beginning of the court's ruling on the record, I tried to make it really clear that everything that I was saying as part of that ruling was all in the context of governmental immunity. And so I think that kind of limits the scope of the order in and of itself, and eliminates the need to get too overly specific with what's in the wording of that order. And so that being said, I did review Exhibit B to plaintiff's response. And I don't know how many different orders were circulated, but I'm referring specifically to the one that was the proposed order attached as Exhibit B to plaintiff's response. I reviewed that. I find that to be more than adequate in terms of reflecting the ruling of the court. I don't think it's necessary to get more specific than the language that's in there. To the extent that the defendants have raised concerns about the language in there, I think those concerns are kind of taken care of by just simply looking again at the scope of the ruling and the scope of the issues that were up for that motion. So in my view, Exhibit B adequately and accurately reflects the ruling of the court. And so that is the order that the court's going to enter. If any counsel from either side wants to get a copy of that order that's actually entered, and I'm going to sign that today, just contact the clerk's office, because I know there are different versions, and I'm sure that you all want to make sure that you know exactly which version has been entered. But that's the ruling of the court, and that's all I have for today. Mr. Elliott, anything further from your side?
No, thank you, Your Honor.
Mr. side.
I don't have anything further, Your Honor.
Thank you. Ms. Olson?
No, thank you, Your Honor.
Okay, thank you all. That's all for today, and all parties are free to disconnect at this time.
Thank you.
Thank you.